All right, well, good afternoon, friends. Thank you so much for making time for this important webinar and for a bit of discussion about some community issues. This is an annual tradition for us. I am Michelle Oldroyd. I represent the CLE department, the education department of the Utah State Bar. And we are so thrilled to be a co-host again this year with the Administrative Office of the Courts, as well as the Society of Professional Journalists, to host the Journalist Law School and to feature a topic of tremendous interest in our community. We often hear about criminal matters that are pending in our courts, excuse me, and we also often hear discussion about sentencing, whether we think it is fair or appropriate or too lengthy or too short. And those debates are ongoing. And we notice that on occasion, the questions being asked are not necessarily finding adequate answers and resources, which is why we've gathered the Utah Sentencing Commission, the Utah State Judiciary, the Administrative Office of the Courts, and the Utah State Bar as resources for you in covering our courts most effectively, just to find places to go with your questions and places to go to explore additional answers and information. I want to thank our faculty and our co-sponsors. On behalf of the bar, we consider this a privilege to be part of this group and to be part of this dialogue, and to acknowledge Monica Diaz, Brent Johnson, and Judge James Blanche from the 3rd District. We are appreciative of your time and expertise and willingness to share with our colleagues in our community your information, as well as your willingness to continue to be a resource for us as we both cover our courts and practice within our courts. We thank you for your expertise and willingness to share today on Zoom. We will be recording today's meeting and offering it at a later date, the recording, so that folks who can't attend today or want to rewatch any portion of this dialogue will have the opportunity. As well, I'd like to invite those of you who have questions throughout this discussion to post them in the chat. We will be moderating a Q&A session following the presentation so that you do have an opportunity to ask your own individual questions and can do so in the chat following the original presentation of the event. And I know the Society of Professional Journalists would like an opportunity to share with you a bit about their organization. So I'm going to turn some time over to Eric to briefly introduce that group. Thank you so much.
Thank you, and welcome everybody. This is super exciting. Have everyone here to learn so much about sentencing. I know this is an area that I'm really curious about, and very excited that we could have this opportunity again, partner with the courts and be able to put on a great event like this. And just real quick, we just wanted to kind of tell you a little bit about SPJ. You know, we represent journalists statewide. We put on a lot of events such as this one throughout the year. We're going to be having a regional conference in the spring. Haven't quite settled on the date on that yet. We were actually supposed to have it last spring, but COVID happened, so still adjusting. And we are going to be having an event in October, kind of prepping, how to kind of prep for the vice presidential debate. Still nailing down a few details on that, but if you're interested in learning more about SPJ events or becoming an SPJ member, I would recommend you reach out to us. You can contact us at utahspj@gmail.com, or you can email me directly at epeterson@utahinvestigative.org. We also have a Facebook page. It's facebook.com/utahspj. I'll throw that info up in the chat as well if you want to look at that. And with that, we'll turn it over to Jeff to get this started. Thank you.
Jeff, you're muted.
That is going to be the motto of 2020, is you're muted. Sorry about that. Thanks, Eric. My name is Jeff Fatah, for those of you who don't know me. I'm the Communication Director for the Utah State Courts. This is our latest in our series of Law School for Journalists seminars that we have been holding in conjunction with the Utah Bar and the Utah chapter, Headliners chapter of Society of Professional Journalists. So we're glad you guys can join us. As mentioned, this is the topic is going to be on sentencing. We have Monica Diaz, who's the director of the Utah Sentencing Commission. We have 3rd District Judge James Blanch joining us. And then we also have Brent Johnson, who's our lead legal counsel for the Administrative Office of the Court. We're going to take you through a 20-minute presentation and kind of give you guys an overview of sentencing. And in Utah, that's what's really a big challenge for us is that Utah sentencing by law is indeterminate. And so Monica is going to take us through that presentation and explain what indeterminate sentencing means and some of the things and information and influences that come in from all directions when it comes to determining a sentence in the state of Utah. So I will turn it over to Monica.
Thanks, Jeff. Let me see if I can share my screen here. Can everybody see that?
Yeah.
Okay. So thank you all for having us, and Judge Blanch and Brent, feel free to jump in whenever you want. Just a little bit of an overview for everybody about the Sentencing Commission. We were established in 1993. We are a 27-member board. It's comprised of legislators, prosecutors, defense attorneys, judges, Department of Corrections and Probation, the Board of Pardons and Parole and the Youth Parole Authority, victim representatives, citizen representatives, treatment representatives, and juvenile justice services. And so those are the stakeholders that comprise the Sentencing Commission. Our job is to develop guidelines and legislative recommendations, policy recommendations to all 3 branches of government that regards sentencing and release of individuals, as well as supervision on probation and parole. We are unique, but I think we are one of the few branches of the executive branch that works with all 3 other branches of government. In terms of sentencing and release, we respond to public comment. We try to relate our practices to correctional resources. We're looking at increasing equity in the system, better define responsibility of sentencing, keeping discretion of judges, but also preserving the role of the Board of Pardons and Youth Parole Authority. So the Sentencing Commission creates guidelines based on evidence-based sentencing policies that will effectively address risk management, risk reduction, and restitution. These are really the goals of the sentencing guidelines and what we aim all the policy decisions at. When we talk about evidence-based, we're not talking about evidence that is usually presented in court. What we're talking about is practices that have been empirically shown to improve outcomes for individuals convicted of a crime. This is not uncommon for other practices or professional fields. Medicine uses evidence-based practices. Even sports uses evidence-based practices. I think most people are familiar with the defensive shifts in baseball, the science behind three-point shooting in basketball, and that's all evidence-based. So that's not any different from what most professional fields use. When we talk about evidence-based, what we're really talking about as well is taking the best research and data, public input and concerns, and the history and value of professional judgment and experience, and combining all of those. Historically, they have all sort of developed independent of one another, but really where they intersect here in the middle is where you get evidence-based practices. It's important to remember that this is a dynamic process, and so what is evidence-based at one period of time may change over time as we get better research, better data, as we look at input concerns and have more experience. So before we talk about what goes into a sentencing, it's important to know how do we actually get to the sentencing phase in court. There are sort of 2 methods of getting there. There is a plea bargain. At its basic form, the plea bargain is an agreement between a prosecutor and a defendant, whereby a defendant will plead guilty and in turn get something from the prosecutor. So it can be a reduced charge in terms of felony and misdemeanor or dismissed charges. It could be changing the name and the statute of the actual offense charged. It could be a sentencing recommendation, or it could be all of those. Judges aren't usually bound by plea bargains in terms of like sentencing recommendations. And this is one that I think is important for the media and the public to know, is in a plea bargain, facts are generally established by what's called like a plea affidavit, sentencing briefs, and things that are actually given to the judge. The other way is a trial, where facts are established by the evidence presented at trial, and then the conviction of the charges are determined by the judge or jury. Facts that are proven at trials, or that a jury or judge uses, that's what can be considered by a judge at sentencing. So it's probably easiest to talk about sentencing in terms of frequently asked questions. And the new sentencing guidelines will also have a frequently asked a section on it so that you could refer back to it. Those will come out in 2021. So what decisions will the judge make at sentencing? A judge will decide whether to impose the recommended sentence. They can deviate higher or lower based on aggravating or mitigating circumstances. I don't know, higher or lower is a technical term, but increase or decrease the sentence based on aggravating or mitigating circumstances. They can decide whether or not they're going to suspend a sentence, and we'll talk in a minute about what a suspended sentence actually is. And they will decide whether they're going to impose fines and restitution. So what information does the judge use to make that decision? They'll use a pre-sentence investigative report that is done by the Department of Corrections, APMP, and that includes a lot of information we'll go over in a minute. They do not do pre-sentence investigative reports generally for low-risk individuals. Low-risk individuals can be deemed low risk, moderate risk, high risk, or intensive risk. And that is based on a validated risk assessment. So that's how that is determined. And then a judge can consider information from a prosecutor, defense attorney, victims, anything that's deemed relevant. They can't take into account facts that haven't been proven or agreed upon in a plea agreement. And so sometimes there is information that is reported in the media that a judge may or may not know because it wasn't it wasn't included before the court. And judges don't generally read media reports about their own cases, as they're supposed to be fair and unbiased and impartial. I think it's also important to note that a common misconception is the prosecutor represents the state, not the victim. So if there's a victim in a case, the prosecutor is not their attorney. The prosecutor represents the general interests of the state. And so sometimes you'll have those interests being different from what a victim is interested in seeing happen. And so just knowing those roles is really important in reporting information. So we talked about I mentioned the pre-sentence investigative report, and that, as I said, is done by APNP. It'll include information about the type of offense and information about the offense, the risk needs assessments and how those came out, what services they indicated a defendant needs, the availability of those resources. It will include statements from a victim, and sometimes called a victim impact statement, information about restitution, public safety concerns, and then the Department of Corrections can establish by statute any other criteria that they would like considered. So often, I think the questions faced by the media and the public is, why isn't the sentence what I expected? It's too harsh, it's too light, what's going on here? So first and foremost, every case is unique. It's without the specifics of each case, it's hard to predict exactly what is going to happen. The sentencing guidelines are a starting point, and they would reflect a typical case. But as I just said, every case is unique. Judges can consider aggravating and mitigating circumstances. And then, as I said, judges can only consider evidence and facts that are properly before them. So maybe they have different information than what's been reported. As Jeff talked about, we have indeterminate sentencing in Utah. And what that means is that the sentence imposed has a range of time rather than a specific period of time. So what we hear in the movies or in other states is a judge or somebody sentenced to 5 years in prison. Utah doesn't. Yes.
Excuse me, we just have a question about the previous slide. What determines the risk level? Is it the crime or the person or something else?
So what determines the risk level is a validated risk assessment. AP&P uses what's called the LSRNR. So these are assessments that look at dynamic criteria and static criteria. So it will take into consideration criminal history, but it also takes into consideration education, jobs, a bunch of factors, pro-social things that you're looking at, and then it gives a score that comes into those ranges. And so, and these are assessments that have been researched and validated so that for a general population, and so you're getting a range. That answer that question, but it's not the crime alone. Okay, if there's a follow-up on that, let me know. I can bring up some specific information too at the question and answer time if we want.
Monica, there is actually a follow-up on that. When you say reported, does that mean info presented to the judge in trial or in the media?
What I'm talking about is in the media, and what we hear is sometimes an abundance of facts that maybe a judge hasn't seen, right? It's not properly admitted, or it wasn't what's agreed upon in a plea negotiation, and so the facts might be different. Not that they are different, but what a judge knows may be different from what the general public knows. So the range of time, for example, the standard range of time for a third-degree felony in Utah is 0 to 5 years. It means that a person may spend little time in prison, but they can also spend 5 years in prison or anywhere in between. So the 0 literally means 0, 5 means 5. That's the maximum somebody can spend in prison. And the indeterminate sentence applies in all cases where a judge sends an individual to prison rather than giving them probation. So who determines the indeterminate sentence? The legislature has created all the time frames for which those sentences are. So they specify infraction, misdemeanor, or felony. And for felonies, the indeterminate timeframes for a third-degree felony is 0 to 5 years, second is 1 to 15, and a first-degree felony is 5 to life. This is, of course, generalities. There are crimes that have sentencing enhancements, like rape of a child, which is 25 to life. So you have to look at specific statutes.
Can I jump in on this for just a second?
Yep.
Just to kind of add my perspective. So I've been a judge now for 8 years, and I think one of the sources of most confusion among just members of the public in Utah about how sentencing works is exactly this idea of indeterminate sentencing. And I think one of the reasons that I feel this way is that before I was a judge, I was not a criminal lawyer. I was a civil lawyer, but I have a criminal calendar now. But I had been a member of the public in Utah for 20 years, and I'd been reading newspaper articles and things, and I did not understand when I became a judge, I'm a little embarrassed to admit, how indeterminate sentencing worked. I was aware that there were ranges of time that people could serve when they were convicted of various crimes, and they are the ranges that Monica put on her slide: 0 to 5 years for third-degree felony, 1 to 15 for a second, with some exceptions, 5 to life for a first-degree felony. But I didn't understand what that meant exactly. And what I thought it meant, and what I think a lot of members of the public think it means, is that within those ranges, when a judge sentences someone, the judge picks the time. And the judge will say, okay, well, let's see, it's 1 to 15, I pick 4, or I pick 7, or something like that, and that's the sentence. That is not how it works. So if I'm a judge and I have someone who is either who has pled guilty to a second-degree felony or has been convicted by a jury of a second-degree felony, and I have to decide how to sentence the person, I really have one of two choices. I can decide based on all these factors that Monica has talked about whether to send the person to prison, or I can put the person on probation. If I decide that the person deserves an opportunity at probation, then the person will have a suspended prison sentence and the person will be on probation with various conditions. Those conditions can include serving some time incarcerated, but only up to a year. And then other conditions can be imposed, like treatment and community service, restitution, other things like that. No contact orders are often part of sentencing conditions. But if I decide to send the person to prison, the sentence is 1 to 15. It's not 7, it's not 8, it's not 4, it's 1 to 15. And then I lose jurisdiction over the case, and the Board of Pardons and Parole, which Monica is going to talk about in a minute, then assumes control over how long the person is going to serve. I'm like one of these judges that Monica mentioned. I don't read newspaper articles about my own cases. I certainly don't read the comments about newspaper articles involving my own cases, but I've sometimes read the comments about other cases. And I think that there is a great source of confusion in the public generally about what these sentencings mean. And so you'll often see comments when someone gets sentenced to 5 to life, as though the sentence is 5 years and that's it. It's a life sentence. There's the possibility that the Board of Pardons and Parole can decide to parole the person sooner than that, after they've served at least 5 years. But that range is committed to the Board of Pardons and Parole. And if I were to try to do something else, if I were to say, well, this is a first-degree felony, but I think it's more serious, so I'm going to sentence the person to 10 to life, that would be an illegal sentence and I'd be reversed for imposing it. All I can do is impose 5 to life if it's a first-degree felony that carries that penalty. And so I don't think it's that the articles about these sentencings are misleading. I don't think that they are. It's not like I read the articles and I think there's something wrong in here. I just think it's a source of great misinformation and misunderstanding among the public generally about how indeterminate sentencing works. Part of that, I think, is due to the fact that our system, I don't think, is quite unique, but it's unusual. There are maybe only 2 or 3 jurisdictions in the country that have true indeterminate sentencing like this. Most of them do have sentences where the judge decides a sentence within the range. We just don't. And so I think it's useful for journalists to understand that, and that it might inform some of your reporting on sentences.
Thanks, Judge. So as Judge Blanche said, once a judge sentences somebody to prison, they lose jurisdiction. The Board of Pardons will determine when that individual is released from prison. They redo all the sentencing guidelines and matrices that were done by AP&P. This is sometimes because you'll have an individual being sentenced somewhere in 3rd district, somewhere in 2nd district, and then they combine all of those. But if you only have somebody on one case, you should be able to determine the presumptive prison sentence on the forms 1 through 3 in the guidelines. So this is Form 1 from the sentencing guidelines. If you look at it, the thing that's important here to note is these numbers are the presumptive time somebody will spend if they go to prison. And I point that out because what you have here is if an individual falls in this light gray section, it's jail as a condition of probation is presumed, and in the dark gray section, it's a presumptive probation. But this isn't their probation length. This isn't their jail length. As Judge Blanche said, you can only go to jail for up to 1 year. So 20 months wouldn't, remember, I can't click on my screen. 20 months wouldn't be a possible jail sentence. So if the recommendation was jail and probation, but a judge chose to send that individual to prison anyways, their presumptive time in prison would be 20 months. So that's maybe one thing that's a little confusing when looking at the sentencing guidelines, and so I just wanted to point that Can a judge impose an alternative indeterminate sentence? Judge Blanche already answered that, no. The only option is either to impose the prison time or suspend the sentence. A suspended sentence is delaying the prison time or jail time, and that person serves an alternative form of punishment. So they could be put on probation, they can be sent to jail, or both. And I think it's important for everybody to understand that that original sentence is, oh, it says heard, that should say head, is really hanging over their head. So if they violated their probation or some condition that the judge put on them, they could really then serve their original prison sentence. Jail time, like I said, is not determined by that matrix you looked at. There's another form in the sentencing guidelines that suggests how much jail time should be served to the judge. Now, a judge up to a year for any felony could put him in jail, but there is some recommendations. And probation also is not determined by that. Generally, there is a mandatory starting point for supervision, and that's in the supervision length guidelines. A person could not serve probation longer than their maximum sentence. So for the third degree felony, 0 to 5 years, that 5 years is that cutoff. But there are some mandatory starting points. One thing that we want to clear up is probation is usually a lengthy imposition on individuals. So what does that look like? Again, there's these supervision length guidelines that will determine the length of time. This is the general matrix just pulled right out of the supervision length guidelines. That first number you see is the mandatory starting point for probation, and you can determine whether this is based on the degree of the crime, what their probation starts to look like. That's the mandatory starting point, but this is the general matrix. So there's also a homicide matrix, a sex and kidnapping offense matrix, and a misdemeanor matrix that will all have different times on them. There's jail as the initial condition of probation. And so if a judge doesn't want to send an individual to prison right off, they can send them to jail and then put them on probation. Jail is limited to 1 year. Probation needs to address the risk and needs that were identified in the assessment. Individuals have, yes.
Another question, what is that second number next to the 36, the 18 in that instance?
So the 18 is a early release number for the earliest you could be released from probation. So if you were to complete all of your case action plan and all the orders by a judge at 18 months, then you could, APMP could request an early termination from probation. It has to go before a judge, and a judge determines that. But you have to meet all your conditions of probation. So that would include restitution. There is you can look in the sentencing in the probation guidelines, but there's a reduction in risk. So that risk assessment we talked about. So if you were a high, that you've decreased your risk, things like that. That's what that second number is. You have to have check-ins, and then you've got to abide. Sorry, go ahead.
Monica,
Yeah.
So the mandatory starting point, is that not really mandatory if it can be reduced to 18 months? How does that work exactly?
Sorry, I'm gonna go back.
Can I just jump in and just add a little perspective, just a practical perspective based on my experience? This is Judge Blanche, but we've had these mandatory supervision length guidelines for a relatively short period of time. You all may remember covering the Justice Reinvestment Initiative that was passed by the Utah State Legislature a few years ago, and that was really the omnibus legislation that ushered in this approach to evidence-based sentencing. And there are a lot of provisions of the Justice Reinvestment Initiative that focus in on how long should someone be on probation, what kind of probation should they be on, what are the circumstances under which they should be entitled to have probation terminate early. The Sentencing Commission, upon which Monica serves, has, as part of its statutory charter, the responsibility to develop supervision length guidelines. And they developed these guidelines maybe a year and a half ago, 2 years ago. And they are mandatory on the judges in terms of a starting point. So when you look at this slide and it says third-degree person offense, that means that if I elect to put the person on probation, these mandatory supervision length guidelines require that I start out by putting them on a period of probation of 36 months. So that is the starting point. And I'm not supposed to go up from that or down from that for the starting point. Now, that doesn't mean that the person is going to be on for exactly 36 months or less than that or more than that. Lots of different things can happen with respect to individuals. It's just that that's where you start, and then things end up getting tailored after that based on the person's performance on probation. There is a concept that's built into the approach to sentencing now called earned compliance credits. And so there's an early termination date that everyone gets, and that's usually halfway through the person's starting term. So if somebody gets sentenced to 36 months, there's an early termination date of 18 months. And that means that the person is going to have a right to have AP&P and the court, if appropriate, take a look at whether the person is entitled to have probation terminated early after 18 months. And basically, if someone has done everything that the person is supposed to do on probation, has done all treatment, has paid restitution, hasn't committed any new criminal offenses, has been checking in with probation, doing what he or she is supposed to do, then at that point, the person has a right to be terminated after serving half of the period of probation. So you'd have a right, if you've done everything under the rules that are in place now, to be terminated after 18 months. But sometimes you have a situation where the person has violated probation in various ways, hasn't completed everything, so they won't get to be terminated early. Sometimes you'll have a situation where AP&P will send a report in when 18 months is rolled around, and they'll say, well, the person is doing great on probation, but part of what the person has to do on probation is to do treatment. It's a 2-year treatment program. The person's compliant with everything, but it's going to take another year or another 6 months or something like that to complete probation. And what you'll do in that situation basically is say, all right, well, the person, and the rules provide this, the statutes and rules provide this, the person will continue on probation until the person has completed the treatment. So it ends up getting tailored to the individual based on their own facts and circumstances. Once they've performed on probation a little bit, that 18 months, you'll see it's halfway through the 36. And if you look over on the left, when you see that if the presumptive starting point is 48, then the number is half of 48. That's the early termination date. That's 24 months. And so that's just sort of the counterpart of the 18 months if the person starts at 36 months. And so we start with kind of one size fits all with the 36 months, but then everything changes to be tailored to the individual after that.
Thanks, Judge Blanche. And as Judge Blanche said, these are fairly new. I think what was happening is because you could have a range of probation on 36 months, it might have been a little more inconsistent between jurisdictions, between judges. And so this is just the starting point for judges. If someone were to be non-compliant, of course, probation could go all the way to their 5-year mark. But we're hopeful that's not what's happening. There's also conditions of probation, and they're general and specific. So the standard conditions are imposed on everyone. There can be special conditions. There are sex offense conditions. If an individual is being electronically monitored, there's conditions on that. And then there's gang program conditions. So just a quick look at what the standard conditions look like. AP&P is allowed to visit you at your home or work. You have to report in terms of check-ins. You can't move without permission. You cannot leave the state without permission. You have to follow the laws and your court orders. There's no weapons. You can't use substances or drugs. Again, AP&P is allowed to search your person, your residence, your vehicle. You need approval to associate with anyone else who's been convicted of a felony. You have to maintain full-time employment and notify your agent with any changes within 48 hours. Be cooperative and truthful. There's a $30 a month supervision fee. You have to submit to DNA, which also has a fee. you have a curfew, comply with your case action plan. So when we look at how to determine your presumed sentence, which is, I think, most of the time what is people are trying to do, the public, the media, how did we get to a sentence? You have to look at the very specific charges that somebody pled to or was found guilty of, and you determine which form you're going to use. Form 1 is your general offenses, Form 2 is homicides, Form 3 are the sex and kidnapping offenses, and Form 5 is misdemeanor offenses. If you don't know what the crime, which form to use, we have this addendum, and it lists out a bunch of crimes and tells you which form to use. Then what agents are doing is they are calculating that criminal history score, which takes into other felony offenses, how somebody did, if they've been on probation before, their crime-free gaps. In some circumstances, it'll account for a juvenile history, and they come up with that presumptive time frame, whether it's probation, jail as a condition of probation, or incarceration. As the media, you may have to work backwards, right? You don't always have all the information, and so you may have to take that score and work backwards to try and figure out the category that somebody's in. And then again, as the media, if it was jail that was imposed, then you'll want to use Form 4 to try and figure out those categories. And finally, the judges don't address the media. I know that Jeff gets requests sometimes if a judge wants to respond to something or to the public, but there are specific rules that keep judges from doing that. So as I stated early on, they are impartial, they're supposed to be fair, unbiased, and so they aren't generally reading their own articles. They don't need to be influenced by the public, and so it's generally why they're not reading it and not responding. Okay.
Thanks, Monica. And now we want to spend the remainder of the hour answering questions, having discussion, and so forth. So feel free to unmute yourself if you want to ask a question, and we can talk about some of the issues you guys might, or questions you might have.
I have a question. This is Bill Hardesty. I go back to something I wrote in, and it probably got cut. You know, you have that screen with 3 circles, and obviously the 3 circles look equal because that's what we do on graphics. In reality, does one circle a little larger than another, or does that circle change over time? Who wants to handle it? Come on.
That's a great question, Bill. Well, I think they all come in the terms of when the sentencing guidelines are being developed, we really do try to take the best evidence-based practices and put them together to make what we are setting out. But then I think what you have is judges are applying them, right? So and so are APMP agents are making their recommendations. So that's your professional opinions and histories, what you get. And then the public really does sway legislation, right? And legislators respond to their constituents. They change offense levels based on that. We expand legislation, we scale it back. And so it's 3, yes, one may at one time drive something more than the other, but we really try to stay at the Sentencing Commission neutral, unbiased, and basing stuff on facts. But if somebody says this isn't working, we're willing to look at it. It won't be a knee-jerk reaction. We will take the time to study and research it, but it's something we're going to look at if that is brought to our attention.
Someone being a judge, someone being a lawyer, someone being Joe Public.
anybody. I get emails and response from the public all the time, and we will look at it. It doesn't mean that it's wrong, or maybe it was. And so we will look at it and try and work through it, but it could be anybody. I get letters from inmates all the time. It may not be something we can change, but if it was even something as simple as nobody explained this to me, it's something we're gonna bring up, right? Little things, it may not change the policy behind it, but we're absolutely willing to look at everybody's concerns.
I'll just jump in with a couple of comments, and then people will probably think of other questions as I speak. But there were a couple of things that occurred to me that I was interested in weighing in on when Monica was going through her presentation. One of them was early on, she had some slides that talked about the judge not being bound by recommendations, and that the judge will take into consideration recommendations. And there are really two kinds of recommendations that the court can take into consideration. There's the recommendation that comes from adult probation and parole, and that might be if the person has pled guilty, it might be if the person was convicted at trial, and you get this pre-sentence report that makes a recommendation. That is not binding. It is something that judges take seriously, and usually will articulate a reason if they're going to depart, either upward or downward from what's recommended by adult probation and parole. Those recommendations are never binding, and those are just things that the judge can and you almost always will take into consideration. The other kinds of recommendations are these recommendations that the parties agree to make to the judge. And so that would only be in the context of a situation where a person pled guilty to something. And the parties will negotiate back and forth, well, what will the person plead guilty to? What will the person get in exchange for pleading guilty? And what the parties will often agree to is they'll make an agreement that the prosecutor will recommend something to the judge. And it might be a recommendation that the person get a chance at probation before a prison sentence is imposed. It might be a recommendation that the person serve a particular amount of time in custody before getting a chance at probation. Could be really anything else. Most of the time, those recommendations are presented only as, we agree to recommend this to the judge. So it's a united front. Both sides are asking for the same thing. In the 90% circumstances where it's just an agreement to make a recommendation, the slide is right, that those are not binding on the judge. There is one exception to that, and that is what's called a Rule 11 plea. So Rule 11 of the Utah Rules of Criminal Procedure says that as a general rule, it's unethical and improper for a judge to get involved in negotiations over the disposition of a criminal case. So I don't push the parties to settle cases. I don't weigh in on what I think the settlement would be or anything like that. The parties handle that. The one exception to it, and it's found in Rule 11I of the Utah Rules of Criminal Procedure, is that in certain cases, the parties will come and they'll say, all right, we've negotiated this, we've agreed to recommend this certain thing, but it's such a key part of our negotiation that we want to present this to you in advance. And we'll tell you about the facts of the case, and we'll answer any questions that you have. We'll convince you that this is in the interests of justice, but we want you to commit in advance that you will impose this sentence if the individual pleads guilty to this offense. And so that's what's called a Rule 11I plea. It's where they get advance approval from the court. And then that would be binding. Typically not binding in the sense that I would lack all power to impose a different sentence. But if I were to deviate from what I committed to do in one of those rare circumstances, then the individual would have a chance to withdraw their plea and go back to square one if I were not inclined to go along. So that is the one set of circumstances where a judge can be bound in advance to follow a particular sentence. So that's one observation I had as we were going through. Monica also made the comment about how prosecutors in criminal cases don't represent the victim. And that is true, strictly speaking. However, there are statutes and constitutional provisions that talk about victims' rights. And victims have certain rights to be notified and consulted with by the prosecutors in certain kinds of cases. And so even though the prosecutors don't represent the victims, they have statutory obligations to talk to the victims about certain things, notify the victims about certain things, involve the victims in certain procedures, give the victims an opportunity to object if they want to. So even though it is true that they don't represent the victims, they have obligations under law to involve the victims in the proceedings.
Judge Blanche, we have several questions for you here in the chat. The first one is, if someone is sentenced to 3 consecutive sentences of 2 to 20 years, how long is that sentence? Is it accurate to say the person was sentenced to 60 years in prison or 6 years in prison?
Well, so if it's consecutive, it would essentially be 6 years to 60 years in prison. But there is a statute that caps out the amount of time that someone can serve at 30 years. And now, if the person, if the top range is life, then that doesn't apply. But so, for example, if someone got sentenced to 3 consecutive terms of 1 to 15 for second-degree felonies, you might say, well, that's 3 to 45. And it essentially would be 3 to 45, except for the fact that in a situation like that, there's a statute that would limit the top end of the cap to 30 years.
I'll just jump in really quickly. How it's generally calculated is you take the most serious offense and you take that presumptive time frame. So the one we were talking about was 20 months, so I'll just pretend it's that. And then all the lower crimes that have been running consecutive, you do 40% of that sentence and add it together. Mm-hmm. So if they were all 20, that would, I'm so terrible at math, but that was what, 8? And then you add it up. So that's the general calculation. But again, as Judge Blanche said, somebody could spend 30. But for the general calculation for the Board of Pardons, that's how they do it. So the initial the most serious crime, and then 40% of the time for each additional crime.
Yeah, and we're not talking about different things. It sounds like what we're saying is inconsistent, but it isn't. So the actual range of sentences, if you were talking 2 to 20, it would be essentially 6 to 60 if it were 3 consecutive sentences. Limited statutorily, I probably limited to 30 under that statute. I don't want to apply the law or give an advisory opinion about anything, but what Monica's talking about when she's talking about adding the 40% is she's talking about those numbers that are in the matrix that are the presumptive amount of time that the person will actually serve in prison before the person gets a chance for parole. So the range would be adding together, if they're consecutive, adding together the lower end and then adding together the upper end, applying the statute that might limit it to 30, but then how much time do they actually presumptively serve before they get a chance at parole? That's what Monica's talking about.
The next question, Judge, is where do judges have the most discretion? Are there areas where you think the system would be improved if judges had more discretion?
Well, that's a policy question, and I think different people have different views about that. We have the most discretion in terms of what we require someone to do when they're on probation. And, probation is something that sometimes gets derisively referred to, again, by some of these commenters in the to the articles that get published as a slap on the wrist. Probation is pretty rigorous for all the reasons that Monica laid out in her slides. It's not something that any of us would want to have to endure. It's people looking over your shoulder, people coming in, you've given up your rights to privacy for various things. You get visits at a moment's notice to come and inspect your place. So probation is a significant burden for a lot of people. And judges have a lot of discretion in saying, well, here is what the conditions of your probation should be. We have less discretion when it comes to sending someone to prison because we lose jurisdiction of the case at that point. And then the Board of Pardons and Parole decides when the person gets paroled. They have conditions of parole too. And AP&P, the same entity, supervises them on parole that supervises them on probation. That's why it's called adult probation and parole. So probation is for people who get probation. Parole is for people who get sent to prison. But I have nothing to do with the supervisory conditions of someone who gets put on parole. And so one thing that you can take away from that is that it matters a lot who's on the Board of Pardons and what they're doing. And so different people can have different ideas about whether that's a good idea or a bad idea. I mean, an argument you could make against this is that judges have more sort of accountability in terms of retention elections and scrutiny by appellate tribunals and things like that than the Board of Pardons and Parole does. And so you might say that that's not a good thing about the system that we have, giving this much discretion to the Board of Pardons and Parole. An argument in favor of the kind of system that we have is that if someone is going to serve a long period of time incarcerated, who's going to be better situated to assess when the person is a good risk for parole? Is it going to be a judge who's looking into a crystal ball 15 years down the road saying this is the amount of time the person ought to serve before the person should be considered for parole? Or is it going to be an entity that can sort of monitor what the person has been doing, whether the person has made progress toward being paroled? So that is a policy question. It's been resolved in our state from the time of the Utah Constitution in favor of us having indeterminate sentencing and a board of pardons and parole. Like I said, it's unusual. Most states don't have a system exactly like ours, but those are kind of the arguments in favor of it and against it. It's the system under which I operate, and so I don't question its wisdom. I just apply it and try to be as fair to people as I can along the way. But I don't think I can provide much more than that in terms of answering the question.
Another question, Judge, is could you please discuss the relative merits of pleas in abeyance? What is that tool used for, and does it work? And your thoughts on that?
Well, so it's something that essentially is a situation where in a particular case, the parties can propose to the court that there be a plea in abeyance, and it's where the person pleads guilty, but the person's conviction is not entered. And there's an agreement between the state and the defendant that the person could do certain things, and it might be complete a certain treatment program, it might be to pay restitution, it might be just to remain crime-free for a period of time. And when that's over with, the person's charge, the case would be dismissed, and the person's conviction would never be entered. There would still be a record of the case being filed, but the person under the laws of expungement would have the ability to seek expungement of the charges much sooner than if a conviction were entered. So there's a big difference between completing a plea in abeyance situation successfully where the case gets dismissed and then expungement can happen sooner, and a situation where the person's conviction is entered and they complete their probation. Even if they're successful in probation, the case is merely closed. The case is not dismissed, it does not go away, and it's much longer before the person can get the charge expunged. And it's really kind of between the parties, the state and the defendant, whether or not it's a case that warrants a plea in abeyance. Many of you are familiar with the specialty courts that we have: drug court, mental health court, veterans court. The usual approach in those courts is to give people a plea in abeyance, and the condition of the abeyance agreement is that they complete drug court successfully, for example. And then they'll get a chance to get the case dismissed, expunged sooner, and hopefully the treatment that they get in connection with drug court coupled with the expungement will allow them to get a job sooner or get into a school sooner or something like that, so that they can sort of have a practical benefit from the fact that they went through the program and completed it successfully. But it's certainly a benefit for people relative to just pleading guilty and having the conviction entered. And it's decided between the parties on a case-by-case basis. The judge doesn't have to accept it. So I can veto a plea in abeyance if the parties present it to me and I'm not comfortable with it. I cannot force a plea in abeyance on the parties. So I can't say this is going to be in a plea in abeyance whether you want it or not. It has to be agreed to voluntarily, but I can give a thumbs down if I don't think it's in the interest of justice.
And there isn't a tool for that, because as Judge Blanche said, it's an agreement between the prosecution and the defense that has to be accepted. And we try not to bind those types of agreements because they're usually for special conditions. So on a drug court situation where maybe the person could look at 18 months or so, but they need a little bit longer in treatment, we don't want to bind anybody to that. Or if it would go beyond the 36 months, but it's not a terrible thing, they're just doing really well. We don't want to have somebody kicked out of a drug court program because their probation has run out when it's really a benefit to them. Maybe we're looking at a restitution situation where if you pay all your restitution, it's the plea in abeyance. So those are just really nuanced agreements between the prosecution and the defense. And so there's no tool for that. It's just up to their discretion to propose what they think is appropriate for the judge.
I think we have time for maybe one more question. If anybody has a burning question. If not, I actually have one issue to bring up, but does anybody have a last question? Looks like Alex has a question.
Hi, thanks. I guess I was wondering if maybe, Monica, if you could talk about the evidence-based sentencing a little bit more. If I have that right from the beginning, like when you give the sports examples, the goals there are pretty clear, but the goals in sentencing, I mean, I'm not, yeah, if you could just talk about that a little bit.
Sure. So when we look at evidence-based sentencing, what we're really looking at is risk management, risk reduction, and restitution. And so we talked about those evidence-based assessments that will look at somebody's risk based on everything that's going on in their life, their history, current. And so risk management is obviously, we don't want to increase risk for somebody who is high risk or moderate risk. We want to work on what is driving that risk and reduce it. And then restitution is obviously paying back what you've damaged. But so that's the evidence-based sentencing is based on meta-analysis, scientific research, college studies, things like that, that have really shown what works best aimed at all those three things. So when we talk about public safety, which is really, you know, what the justice system looks at is how do we increase public safety by reducing crime? That's what we have to aim at, is individuals' risk and managing that risk and reducing it. So it's like a balanced approach. I don't know if that was if that answered your question. But that's what evidence-based sentencing is looking at, all the research data to drive those factors.
Thank you.
Have one more really quick question. Can a plea deal be entered into after a trial has started? And how does that fit in the timeline?
Yeah, so until a judgment is rendered by a jury, let's say assume it's a jury, or I guess by a judge in a bench trial, a plea deal can be entered at any time. I think Judge Blanche would know how often it happens, but I think what you see is sometimes evidence is rolling out, and it is either going not as expected for one party or the other, and so they may start to negotiate at that point. So until a judgment is rendered by the judge or the jury, a plea deal could still be entered.
Yeah, I think that's right. And it happens fairly often, depending on how a trial is going. Parties may decide to work it out in the middle of the trial. I suppose it's possible, even if a case were on appeal, that the parties could resolve it and come back to you and enter some sort of a plea differently than what the jury's verdict was. I haven't had that particular situation presented to me, but just off the top of my head, it seems like that might be feasible too. But at least during trial, it happens quite frequently.
And I would just want to take a couple quick seconds to mention that one thing that I've noticed in terms of media coverage of certain cases and where a lot of the public seem to get outraged over is the sudden reduction where the base allegations of a petition are horrifying and disturbing to the public. And then the resulting sentence, whether it was by a plea deal or the state makes a motion to reduce the severity of the charges or whatever, are met with shock and a lot of anger. And what I would encourage you guys to keep in mind is that evidence has to rise to the level of proof beyond a reasonable doubt at trial. And so it's a high burden. So if a case is not going well for the state and things start to fall apart or whatever, you're probably not going to hear it from them. They're not going to say, oh, our case is falling apart, or they're going to admit to the court that. And so what you might want to keep in mind is that all that evidence, keep in mind also the defendants are innocent until proven guilty. So that means how is the state's evidence going? Whether that evidence is going to hold up at trial may dictate how something is resolved and resulting in sentencing. So I just thought I'd throw that out there. And we are over our time. Unless anybody has any final questions. I know that we want to be respectful of everybody's time. I would like to thank our panelists for their participation and offering their expertise and their knowledge. Hopefully this will help everybody gain a better understanding of how complicated sentencing can sometimes be in Utah. And as always, you can reach out to us. You can reach out to me. So if in the event that anybody's tuning in after the fact, if they're watching this pre-recorded, you can always email me It's geoff@utcourts.gov, and I'd be more than happy to direct those questions to any of our panelists or anybody else to help you get the information and get a better understanding of sentencing. So with that, I'll turn it over to Michelle for the exit.
Kind of you, Jeff, to do the wrap up there. And thank you, Monica, and thank you to Judge Blanche. Thank you as well to Brent Johnson, all of whom prepared and were welcoming of questions today. I think that's perhaps the most valuable piece of this. While the information and the presentation is so incredibly informative and valuable to our community, this opportunity for dialogue between the media and members of the community who can serve as resources to better serve our journalists as they cover our courts is perhaps the most valuable part of this law school tradition, and we just want to thank everybody for participating. Have a great afternoon. We'll see you soon. Hopefully, perhaps we can gather in person the next time we host the law school. Take good care, everyone.